did they view? When did they chart? The data shows who played what part. Was a note changed? Was an alert displayed? The audit trail knows, while memories can fade. So whether you're a lawyer, nurse, or sleuth, pull up a seat, we'll search for the truth. Every click leaves a clue in the fray. This is what the chart won't say.
Hi everyone, this is Saira Pasha and welcome back to my channel, What the Chart Won't Say. This is episode 2, and if you have not seen episode 1 yet, I strongly recommend that you go back and you start with that video first and then come back to this one. Okay, so this episode is about the life cycle of a medical malpractice claim. I decided to make this video because so many of my future videos are going to involve allegations of medical malpractice, whether it be my case study videos or the true crime videos I plan to make. So I thought it would be helpful to start with just explaining with a broad overview what exactly are the elements of a medical malpractice case and what the steps are between, like I said, the life cycle of a claim, the steps from when the alleged negligent care occurred all the way until the jury reaches a verdict. And just to be clear, this video is not meant to be taken as legal advice, and it's not legal advice. It's just for educational purposes only.
Every medical malpractice case begins with a patient who received medical care. There also has to be some kind of injury or alleged bad outcome. But here's an important point. A bad outcome by itself does not mean malpractice. Some bad outcomes are known risks of medical care. A known risk means something that can happen even when everything was done correctly, and patients are often warned about these risks in advance. For example, infection is a known risk after surgery. You could develop a postoperative infection even if your surgeon and nurses did everything right. However, let's say you had signs of infection, a fever, and an elevated white blood cell count, and your healthcare team didn't act on those signs in time, and the infection worsened to sepsis. That could be a potential medical malpractice case.
Because medicine is complex, it's not enough for a patient or a patient's family member to think that negligence occurred. A qualified medical professional has to review the records and determine whether or not the care fell below the accepted standard. And because I'm not a medical professional, I asked my colleague, Savannah June, to join us for this part of the episode. Savannah is an obstetrics and maternal fetal medicine nurse who owns her own legal nurse consulting business where she does work on behalf of both plaintiff and defense. And Savannah has also attended several of my, maybe not even several, I think all of my audit trail classes that I've held live in person. And she is, quite frankly, brilliant. Hi, Savannah. Thank you so much for joining us. Can you please start by explaining what the standard of care is?
Thanks, Saira. The standard of care is what a reasonably careful and prudent provider would have done in the same or similar situation. It doesn't mean perfection, and it doesn't mean judging with hindsight. It means looking at what the provider knew at the time and what a competent professional would have done in that moment.
And what role do medical records play in this process?
Medical records are critical for this. They show what was observed, what was communicated, and what actions were taken. For example, if a patient has an elevated white blood cell count and a fever, the standard might be to notify the physician and to obtain blood cultures. If the nurse documents that they notified the physician and carried out those orders, that supports meeting the standard. If the nurse ignored those signs and didn't escalate, that could be a breach. When we perform a merit review, we look at those records and decide if what's documented met the professional standards. Nurses evaluate nursing care, and physicians evaluate doctor care, and so on. And that's because only a clinician with similar training can fairly judge whether the care met or fell below the standard. That review is often the first step in deciding if a malpractice case can move forward.
Thank you, Savannah. See you soon. Savannah will be back in another episode airing next month. That video will be a case study video about a real case that I worked on involving an injury to a newborn. But back to this episode. So the next step for us is to go over what the elements are for a medical malpractice lawsuit or cause of action. So I'm going to play a little video that I made right now with some visual aids, and then I will be back.
To succeed in a malpractice claim, a plaintiff must prove 4 elements. Duty. A patient-care-provider relationship must exist. That relationship creates a legal duty for the provider to give care consistent with the accepted standard of care. Breach. The provider must have done something, or failed to do something, that fell below that standard. Causation. The breach must have caused the injury. In other words, the harm wouldn't have happened but for the negligent act. In law, we call this proximate cause, a direct and foreseeable link between what happened and the injury. Damages. There must be actual harm or loss as a result, whether physical, emotional, or financial. Here are some simple examples. All elements met. A surgeon operates on the wrong knee. Duty, breach, causation, and damages are all clearly satisfied. Causation not met. A nurse gives the wrong blood pressure pill, but the patient's stroke later that day turns out to be from an unrelated blood clot. There was a duty and a breach, but no causal link between the error and the injury. Damages not met. A physician orders the wrong lab test, but the mistake is caught and corrected before anything bad happens. There's a duty and a breach, but no damage. These examples show why pointing to a mistake alone isn't enough. The evidence has to connect the dots.
Let's assume a case has merit and the plaintiff's attorney plans to file suit. Once a lawsuit is filed, the rules vary by state. Many states require an affidavit or certificate of merit, a sworn statement from a medical professional confirming that the case appears valid. Some states even use pre-lawsuit review panels, where other doctors evaluate the claim before it can proceed. These procedural steps are designed to screen out frivolous cases, meaning someone cannot simply believe malpractice occurred. A qualified medical professional has to agree. After the complaint is filed, the defendants are served and they file an answer. Then comes one of the most important stages, discovery. Discovery is the formal process where both sides gather and exchange evidence. Evidence, legally speaking, means any information that tends to prove or disprove a fact at issue. That includes documents, testimony, physical objects, and data. In medical malpractice cases, the 2 most common types of evidence are the medical records and deposition testimony. A deposition is sworn testimony taken outside of court, usually in a conference room. The witness answers questions from both sides, and the testimony is recorded by a court reporter. For example, a nurse might be deposed about when she last assessed a patient, or who she notified about a change in condition. Discovery can take a long time, often 1 to 2 years in complex cases with multiple defendants.
I'm back. All right. So the next step for us is to talk about audit trails and where that fits into all of this. We just went over what discovery is. And if you remember, Savannah said at the beginning of this episode that medical records were very important as part of the merit review process. And so those medical records are generated from an electronic medical record system. And what an audit trail is, it's a report generated from that EMR system. And it shows it's a time-stamped report that shows all auditable actions performed by all users in the patient's chart during the care at issue. And those auditable actions are actions like view, access, edit, delete, add, sign, modify, print. So the next episode, episode 3, I go over audit trails in much more detail, and I even show a mock audit trail. So I'm going to save that for that episode. So when this is over, you can feel free to go watch that. It's already posted. So what I do is I review that document primarily for, like I said, deleted or revised notes, but I also use that information or the data that's in that report to reconstruct a very tight timeline of care. Let's say that a note was signed at noon, and the next note that was created for the patient was signed at 3. So let's say something happened in between 12 and 3, and my client wants to know exactly or in much more detail what happened because we have no notes from that 3-hour gap. So I will use the data from this report to recreate a very, very tight timeline by like sometimes seconds about, what was going on in the patient's chart and then telling the story of what the data says. Okay. And the next step is once I review it, I tell my clients what my findings were. And then sometimes those clients want me to explain that to a jury. So that means they will disclose me as an expert witness to testify at trial and explain to the jury what my findings were. And that involves typically me writing an expert report or my client writing a report based off of my ideas. And this is a good time to segue into a little clip I made about expert witnesses.
Once discovery is underway and most fact witnesses have been deposed, the case moves into the expert phase. Toward the end of discovery, or sometimes just after, both sides file something called expert disclosures. This is where the plaintiff presents their final theory of what happened, supported by expert opinions, and the defense does the same. Experts are required in almost every medical malpractice case because jurors and judges typically do not have the specialized medical knowledge needed to determine whether care was appropriate. Medical experts explain what should have been done and whether the standard of care was breached. Both sides can also disclose causation and damages experts.
Okay, so now we went over expert witnesses, and the next step is to go over what happens at trial. But before I do that, I just want to point out that I intentionally made this video to go all the way, to look at a case that goes to trial. The majority of medical malpractice cases don't go to trial. And by that, I mean at some time between the suit being filed and trial, either, typically this happens during discovery at some point, but either the plaintiff attorney realizes that their case isn't what they thought it was, it's not good, and then they will voluntarily dismiss it. And then sometimes the defense realizes that their case isn't that good, and then they will attempt to settle the case. And I would say, depending on your jurisdiction, but roughly, 80 to 90% of medical malpractice cases that are filed never make it to trial for whatever reason. Well, one of those two reasons typically. But, so just keep that in mind that most cases do not go to trial. Okay. And I also want to talk about the fact that my next episode is episode 3 about audit trails. But episode 4 after that is about a case study. I go into a lot of detail about a real case that I worked on that went to trial and I testified in it. And that is episode 4 and it's already posted. So if this video intrigues you and you're ready for more, first watch episode 3, then you can watch episode 4. Okay. So now I'm going to go ahead and play the trial portion, and then we're basically done.
Finally, the case goes to trial. At trial, the jury sees and hears only the evidence the judge has ruled admissible. That usually includes the medical records, the testimony of the plaintiff and defendants, witness testimony from nurses, doctors, or family members, expert testimony, and supporting documents from discovery. After closing arguments, the jury receives legal instructions and begins deliberations. Medical malpractice cases are civil cases, not criminal ones, so the standard of proof is different. Instead of beyond a reasonable doubt, the plaintiff must prove their case by a preponderance of the evidence, meaning it is more likely than not that malpractice occurred. After a verdict is reached, either party can appeal the decision, but an appeal is not a second trial. It is a legal review focused on whether the judge made an error in applying the law or allowing certain evidence. The appellate court does not reweigh the facts or hear new testimony. It reviews the record for legal mistakes that may have affected the outcome. If the appellate court finds an error, it can order a new trial or modify the judgment. If not, the verdict stands and the case is considered resolved.
Well, that's it for this video, episode 2, the life cycle of a medical malpractice case. I hope you feel like you learned something. Let me know in the comments. Don't forget to like and subscribe. And like I said earlier, episodes 3 and 4 are already posted, so you can binge my show for 4 episodes if you'd like. But otherwise, I plan to create a few more videos in the next few weeks, and those will be published soon. So in the meantime, thank you for watching. This is What the Chart Won't Say, where we follow the data and let the facts speak for themselves. Bye.
For professionals in the medical legal field who want to learn how to analyze EMR audit trails, this book was written for you. What the Chart Won't Say is a practical, step-by-step guide that explains how to read, interpret, and understand EMR audit trails in medical malpractice cases. It was created for attorneys, legal nurse consultants, risk managers, and medical professionals who need a clear and approachable introduction to this complex topic. In-person classes will also be offered in early 2026 in the Chicagoland area for those who want to expand their knowledge and apply these skills in practice. Instructions for purchasing the book and signing up for classes will be announced on November 1st.